Good morning. This is the Monday, the 23rd of March, 2020. I hope you're all well. I would just like to speak about the principle of legality in light of the recent comments I made in respect of the Barter Star fishing matter. You'll recall that the principle of legality was introduced into South African administrative law in the PAJA case, where the court found that although the increase of rates and levies constituted deliberative legislative action and therefore was not the subject or did not constitute administrative action, the court went one step further to look at the exercise of public power in a constitutional dispensation, and in this regard drew heavily on Canadian law as well as German law, in saying that what we derive from the rule of law, which is an express provision in Section 1C of our Constitution, is the incident of, the incident of the rule of law is the principle of legality, which holds account the exercise of all public power and or the performance of a public function. The reasoning in this regard aligns itself very closely with the transformative constitutionalism agenda, which speaks to the principles of accountability, transparency, as well as openness, or if you want to consider it from accountability, responsiveness, and openness. All these three factors speak to a culture of justification, where the exercise of all public power needs to be justified in order for it to be lawful and valid as such. So that was introduced in the PAJA case to say that you have to act in good faith. What was previously conceived of as ultra vires under our common law is now looked upon as a contravention of the principle of legality, and also interpreted the principle of legality to mean that you have to act reasonable with, you have to give effect to reasonableness. And the next development in the principle of legality came about with the SAFU case, where in SAFU the court also found that the appointment of a commission of inquiry in terms of Section 84(2)(f) of the Constitution falls within an original constitutionally sourced power which is bestowed on the head of state or the state president, which is the head of the executive, and therefore does not constitute administrative action. But the court went further to endorse the approach in PAJA by saying that in exercising that power, that originally sourced constitutional power, you need to act in good faith and you cannot misconstrue your powers. And then we looked at the pharmaceutical case, the third constitutional court case we've looked at, which was also decided prior to the coming into operation of PAJA on the 30th of March 2000. And pharmaceutical was interesting because Chaskelson pointed out to the difficulty that one often encounters in ascertaining whether the performance of a function or the exercise of a power constitutes administrative action. And with reference to the pharmaceutical case, the Constitutional Court found that the act of the President in signing Proclamation R49 was closer to a legislative function than it was an administrative function. So having found that it did not constitute administrative action as such, for that particular reason, the court still had a look at the principle of legality as introduced into admin law by PAJA and developed in the SAFU case, and said that for the exercise of public power to be valid, it has to be rational. So the minimum threshold of rationality, or the minimum threshold of the principle of legality, is that all exercise of public power, for it to be acceptable, needs to be rational. And then today we've discussed the Barter Star case, which was decided after the coming into operation of PAJA, the national legislation giving effect to subsection 1 of Section 33 of the Constitution. And although Barter Star doesn't develop the principle of legality any further. It certainly endorses the approach of the court in Fetscher as well as SAFU and also pharmaceutical. But what's important about PAJA Star is that it lays down authority that Section 6 of PAJA is now a codification of the former common law grounds of review. It endorses the pharmaceutical reasoning that we do not have two systems of law, we only have one system of administrative law that's to be considered against the values and principles of our Constitution. But more importantly, PAJA Star paragraph 25 says that the judicial review of administrative action no longer arises ordinarily from the common law, but from PAJA. So what O'Regan J., who pens the judgment on behalf of the majority, is saying is that you have to use and employ PAJA when considering or when sitting in judicial review of administrative action. It's also telling or insightful to observe that the finding in PAJA Star was that the director or the chief director's decision to award the fishing quota allocation constituted administrative action under Section 1, the definition of administrative action for PAJA. So PAJA Star has to be considered as the ultimate authority in establishing that your official gateway to judicial review of administrative action now is PAJA and not the common law, and it is also not the Constitution. In other words, you cannot rely directly on subsection 1 of section 33 of the Constitution, which provides for just administrative action. And this, you'll recall, relates back to the importance of the principle of subsidiarity, where you have national legislation giving effect to a broader constitutional right. The very important aspect arising from PAJA Star is the issue of reasonableness, because what was pleaded in PAJA Star is that what was alleged was that the chief director failed to act reasonably with reference to section 62H of PAJA. And in this regard, the court had regard to English authority, and particularly a decision by Lord Cook in the House of Lords in 1999, where the court said to determine what is reasonable, in other words, when to judicially review a matter and on what basis, the court decided that an administrative decision will fall to be reviewed if the decision is a decision that a reasonable decision maker could not reach. In other words, that unlocks the door to the mechanism of judicial review. Why is this so significant? Because the ratio arising from PAJA Star makes it emphatically clear that reasonableness is casuistically determined on a case-to-case basis, just as we do procedural fairness, but more importantly, as pointed out by Scutts in the Supreme Court of Appeal before the matter reached the Constitutional Court, reference was made to judicial deference. And judicial deference is not a question of obsequiousness or judicial respect on behalf of the court towards the other two branches of government. Judicial deference is simply giving effect to the constitutional principle of separation of powers. So just because a court of review does not agree with the decision that an administrator made or a functionary in the executive made is in and of itself not sufficient to interfere and judicially review or set that decision aside. Something more needs to be demonstrated by the applicant. In other words, that the way in which the discretion was exercised fell short of good faith, was not rational, or there was a misconstruence of power. But in the PAJA Star case, that it was a decision that a reasonable decision maker in that situation could not have reached with regard to the evidence that was placed before her or him. So what you need to take from the Barter-Starr case for purposes of the assignment I've given you, which refers to the principle of legality having advantages and disadvantages, is the fact that PAJA is the national legislation giving effect to the constitutional right to just administrative action. And without repeating myself, look at the case law, how the principle of legality has developed. But then you also need to take into account the article I wrote in the Journal of South African Law, 2018, titled Subverting PAJA, the Cause of Much Uncertainty in South African Administrative Law. The point made in this article is that, as you will come to see with some of the cases we'll consider, is that our courts are not harmonious in terms of the path they follow in applying, or the path they follow with respect to judicial review applications. In other words, the authority has established in Barter-Starr that the cause of action for administrative action to be reviewed now arises ordinarily out of PAJA and not from the common law. Essentially what that means is that in bringing or launching a judicial review application in respect of administrative action, you have to rely on PAJA. You have to ensure that the nature of the power being exercised or the function being performed constitutes administrative action for purposes of definition, section 1 of the definition pertaining to administrative action in PAJA, and then base your cause of action on one of the grounds which are now codified in section 6 of PAJA. But as we've come to see, the principle of legality, given its malleability or flexibility, is far more desirable than wading through the complexities and sometimes very awkward, navigable way in which the stringent and rigid definitional requirements as set out in section 1 of PAJA are applied. In other words, in determining administrative action under PAJA is far more difficult than in merely applying the principle of legality to say, wait, the way in which this discretion has been exercised has not been exercised in good faith, or alternatively, it's lacking in rationality, or is even unreasonable, or there's been a misconstruence of power. So that affords the court more flexibility in the way it approaches judicial review applications. The problem with applying the principle of legality, where PAJA should, in fact, and ought to be applied, if it is administrative action, is that we are developing a dual or parallel system of administrative law jurisprudence, where cases which should otherwise be judicially reviewed on one of the grounds set out in section 6 of PAJA are now being judicially reviewed on the basis of the principle of legality. What does this mean, or what does this come down to? All this means is that there's much uncertainty in our law as to whether one must apply for judicial review under PAJA or whether one simply uses the principle of legality. Why is this, or why should this be of concern to us as future practitioners or academics or judges? It's simply that there's a dual system of law being developed, and where there's uncertainty, one is not giving effect to the rule of law. And the rule of law, one of the dictates or one of the requirements, the requisite requirements of the rule of law is that there be certainty in our law. And this certainty can only come by, or can be obtained, if we adhere to our approach to judicial review, i.e., where the EPP or PPF constitutes administrative action under PAJA, then you review it under PAJA. If it is hit by one of the exceptions of PAJA, meaning that it falls outside the definition or requirements of PAJA, only then do you apply the principle of legality. Unfortunately, that is not the approach that is adopted consistently. To give you an example, even where certain acts constitute administrative action for purposes of PAJA, judges prefer relying on the more flexible principle of legality in the judicial review of the power in question or the function in question, rather than having to take on the difficult and complex interpretive requirements needed for determining whether or not the EPP or PPF constitutes administrative action under Section 1 of PAJA. So this is important to bear in mind when answering your online research assignment question. If you have any questions arising from this YouTube clip, feel free to email me. Thank you.